Mr. Rutmore, is your mic on?
I believe it is.
Oh, there we go. Okay.
Does that work? Okay. In trying to convince you that Mr. Depp has carried his burden of proof in proving that he was never abusive to Amber on even one occasion, think about the message that Mr. Depp and his attorneys are sending to Amber and by extension to every victim of domestic abuse everywhere. If you didn't take pictures, it didn't happen. If you did take pictures, they're fake. If you didn't tell your friends, you're lying. And if you did tell your friends, they're part of the hoax. If you didn't seek medical treatment, you weren't injured. If you did seek medical treatment, you're crazy. If you do everything that you can to help your spouse, the person that you love, rid himself of the crushing drug and alcohol abuse that spins him into an abusive, rage-filled monster, you're a nag. And if you finally decide that enough is enough, you've had enough of the fear, enough of the pain, and you have to leave to save yourself, you're a gold digger. That is the message that Mr. Depp is asking you to send. But he doesn't stop there, because in Mr. Depp's world, you don't leave Mr. Depp. And if you do, he will start a campaign of global humiliation against you, a smear campaign that lasts to this very day. He will do everything he can to destroy your life, to destroy your career. That is what they're saying, ladies and gentlemen. And that's what they're trying to get you, the jury, to be an accomplice to. But it's not surprising, because Mr. Depp cannot and will not take responsibility for his own actions. It's always someone else's fault. Just as Ms. Vasquez did and Mr. Chu did, I would like to extend my thanks to you on behalf of Amber and our whole legal team for the care and the diligence with which you have served as jurors in this matter. You've paid attention to every witness, every piece of evidence, and I can't even imagine the sacrifice that you've made in terms of time away from your friends, your family, your job, to be here on this jury. It's a very important role that you're serving, and we thank you very much. Let's pick up where we started 6 weeks ago in opening statement. You may remember that I asked you to keep a simple question in mind, which is, why are you here? And much of what you've heard during the course of this trial, you don't need to make a decision on in order to return a verdict for Ms. Heard on Mr. Depp's claim of defamation. Now, we'll talk about Ms. Heard's claim of defamation against Mr. Depp, and Elaine will address most of that in a few minutes. But your key question to answer is, does the First Amendment give Ms. Heard the right to write the words that she wrote in this article on December 18th, 2018? That's the question. And you cannot simultaneously protect and uphold the First Amendment and find in favor of Johnny Depp on his claim. You simply cannot. You have to decide, should someone be able to write an article like that in the United States of America without being sued successfully, without having to go through the hell that Ms. Heard has gone through? So let's talk about that. And to do that, we get to explain a bit more about the law that you have to follow. This is the op-ed piece. I'm not going to read it to you again. You heard me read it to you in opening statements. And I would urge you, when you're in the deliberation room, read it. Read it again. And I know we focus on it, here and there over the course of the trial, but the vast majority of this trial has not focused on these words, on this piece. This is obviously the paper edition. There's the online edition as well. Now we get a chance to discuss with you exactly what you have to find about this article. Let's try this again. This is one of the jury instructions that you'll get. And I've been so looking forward to being able to actually explain to you, as the judge read all the instructions to you this morning, and I know it was a lot, but we've been looking forward to being able to explain to you what you're here to decide. Because I imagine for some of the case, it's been kind of unclear. What are you being asked to decide? These are the things that you have to find, and you have to answer yes. As Mr. Chu said, you have to answer yes to all of them in order to find in favor of Mr. Depp. So you have to find that the statement was about Mr. Depp, and you can decide that in the context of the article. And I'll get to the arguments that Mr. Depp raises on that in a minute. You also have to find that the statement is false. And we're going to look at the statements here. We're going to look at each of the three statements. And in order to win his claim, Mr. Depp has to prove every single element. And there's a concept in the jury instructions that you really didn't hear from Mr. Depp's side this morning, but you've all heard it, I'm sure, outside the courtroom, which is burden of proof. It is Mr. Depp's burden to prove each and every one of these elements. If he cannot, Ms. Heard wins. If he cannot prove each and every one of these elements under the burden of proof that's applicable, Ms. Heard wins. And there's two different burdens of proof that we'll get to. For all of them except number 7, the burden of proof is greater weight of the evidence. So you weigh the evidence and you decide, has Mr. Depp proven to you the first 6 elements? The 7th one, for actual malice, the clear and convincing evidence standard, we'll get to in a few minutes. But this is what he has to prove, and he cannot do that. These are the 3 statements. And I know you may be thinking to yourself, wait a second, don't we have to decide if Mr. Depp committed abuse? And the answer is no, you don't have to. Because these 3 statements, you can decide as a matter of law, or as a matter of fact, as you weigh the evidence and the fact that they're true. So the first 2 statements I'm going to address together. Then, 2 years ago, I became a public figure representing domestic abuse, and I felt the full force of our culture's wrath for women who speak out. Number 2, I had the rare vantage point of seeing in real time how institutions protect men accused of abuse. When you go back to the jury room to deliberate, you should feel free, like I said, to read the article and think of the article's purpose. The jury instructions also tell you to take these statements in the context of the article. Think about the purpose. The purpose of the article was to promote legislative measures designed to protect victims of domestic abuse, designed to protect people who did exactly what Ms. Heard did, to speak out. That's apparent on the face of the article. And to do that, Ms. Heard talked about her own life experiences as someone who had obtained a TRO against Mr. Depp, someone who had accused Mr. Depp of domestic violence. Make no mistake, and Mr. Depp's side keeps trying to say that we're somehow suggesting that 2 years before she wrote this that Ms. Heard hadn't had anything to do with Mr. Depp. We're not saying that. You heard Ms. Heard herself say, of course, 2 years before I wrote this article, I felt the full force of our culture's wrath for women who speak out after she obtained a temporary restraining order against Mr. Depp, after she became a public figure representing domestic abuse. But the words that she wrote here, and then chronicling her own experience after that, those words are true. Those words are true. Similarly, the rare vantage point of seeing, based on her own experiences post May 27th, 2016, how institutions protect men accused of abuse, those words are true, and the First Amendment protects Ms. Heard's right to say them. Now, the third statement is absolutely true as well, but we're going to take that separately because she didn't write it. Under the First Amendment, the statements have to be false in order for Mr. Depp to win. Now, plaintiff addresses, like I said, an argument that we're not making. And as I said, we're not running from the fact that when she discussed becoming a public figure representing domestic abuse, Amber was speaking it is. He has to show you that any defamatory implication was designed and intended. Look at number 4. Designed and intended by Ms. Heard to convey the defamatory meaning that he suggests. Just because people might read the article and remember, oh yeah, Amber Heard used to be married to Johnny Depp, and she accused him of abuse, that doesn't mean that she designed and intended defamatory implications in writing about herself. And think about it. If Mr. Depp is right, then virtually any statement that anyone could ever make about their own life that implies anything, implies any involvement with any other person, could be defamatory. And that's clearly not what the First Amendment intends. She didn't design and intend the words to be the equivalent of writing Johnny Depp abused me. And you don't have to take her words for it. You can take the words of Terrence Doherty of the ACLU. He said that the op-ed wasn't even Ms. Heard's idea. The ACLU wrote the first draft, and great care was taken in drafting the article so as not to make it about Mr. Depp or Ms. Heard's relationship with him. That's the only evidence presented about Ms. Heard's motive, except her statements that that was exactly what she wanted to do. She wanted to talk about her experiences after Johnny Depp. She wanted to own her story after Johnny Depp and fit those into what other women experience, what other people experience having accused someone of domestic abuse, and the backlash that they suffer, and then talk about legislative measures that could help protect people in those positions. That's what she meant, and that's what the article is about. There's no hidden meaning here, ladies and gentlemen. This isn't a hit piece on Johnny Depp. This isn't a hit piece on Johnny Depp. And you can end here. You can end there by saying the statements that she wrote were not false, and the First Amendment protects them. Let's talk about the headline for a minute. The headline that was published in the online version only of the article on December 18th, 2018 said, "I spoke up against sexual violence and faced our culture's wrath." A few points here. Number one, and this evidence is undisputed. There's no dispute about this. So as you weigh the evidence, you don't have to check your common sense at the door, and you can weigh circumstantial evidence, you can weigh facts, but you can't see evidence where no evidence exists. And the undisputed evidence here is that Ms. Heard didn't write the headline, she didn't approve the headline, she had nothing to do with it, she was not given notice of the headline. She testified, you saw her testify about the sexual assault that she experienced at the hands of Mr. Depp. You saw her testify about that they're calling her a liar. You saw her on the stand testify with your own mouth, with her own mouth, exactly what she went through for the first time in court, because people who have suffered that, they don't want to broadcast that to the world. They want to penalize Ms. Heard for not speaking about that earlier. That's ridiculous, and it's insulting, and it's just victim blaming at its most disgusting. The only reference to sexual assault in the article, and you can read the op-ed, is sexual assault that she said she had experienced by the time she was of college age, before Mr. Depp. So there is a reference to sexual violence in that article, but it's not by Mr. Depp. And Mr. Depp can't hold her liable for a headline she didn't write, that contained something that had nothing, that was not about him. And they want you to think that she republished the headline by tweeting out the link to the online version. So let's look at this. This is the tweet that she sent on December 19th. The hyperlink says, "Opinion Amber Heard, I spoke up against sexual violence." That's the online version of the article. As Ms. Heard said, you can't attach, you can't tweet a piece of paper. So when she wanted to share that she had written this article, what choice does she have? She has to attach that link. And the jury instructions that you have make clear that a hyperlink is not republication. Forwarding a link on does not mean that you've broadcast the statement again, but that's what they want to make you think. The only way, and the jury instructions that you have, and we don't need to read through them in detail now, but the republication instruction says that merely linking to an article does not amount to republication, but adding content to a linked article may constitute republication. You must determine whether any added content was intended to reach a new audience, and if you find any content added to the hyperlink was intended to reach a new audience, it constitutes a republication. There was no content added to the article. She tweeted above the article simply saying, "Today I published this." That's what she said. She didn't add any content to it. She could have added some of the content that you've heard in this courtroom to it. She could have said, not only did 2 years ago I become a public figure representing domestic abuse, but let me tell you about the domestic abuse that I suffered. That would be adding new content. This is not adding new content. But I guess it's no surprise, because this whole case is about blaming Amber Heard for things she didn't do. But that's what Mr. Depp does. It's what he's always done. Blame other people, refuse to take accountability. But the problem for him here is that he's running headlong into the United States Constitution, which says that you cannot hold Amber Heard liable for words she didn't write or publish. But here we are. Here we are. And you can decide this case without ever wading into any of the allegations, the facts, the evidence that you've heard about the heinous abuse that Ms. Heard suffered at the hands of Mr. Depp. You can decide that by determining that those statements are true and that they're protected by the First Amendment. But Mr. Depp brought this case, and he's suggesting that he was never abusive to Ms. Heard. So if that's where you want to make your decision, that's where the road ends for Mr. Depp.